and welcome to Bloomberg Quint. You're watching the Fineprint. The report is like buying new shoes. It's tight in the beginning, but it will become comfortable over a period of time. That's how former Supreme Court Judge Justice Srikrishna described the suggestions on the new data protection law for India. Chaired by Justice Srikrishna, the expert committee has made a whole host of suggestions to ensure data privacy. Here are some of the key ones. The definition of personal data must be kept flexible, but sensitive personal data must be defined to include passwords, financial, health data, sex life and orientation, biometric, genetic data, caste, tribe, religious and political beliefs. Consent should be the basis for processing personal data. Additionally, data fiduciaries should be held liable for harms caused to the data principal after consent is taken. Community data, for instance, information collected by apps such as Google Maps, must be protected. Data fiduciaries will be able to use the data only for the stated purpose. Processing of personal data using big data analytics can be undertaken only with explicit consent. Consumers should get a variety of rights such as confirmation, access, correction, data portability, etc. A redressal mechanism in the form of Data Protection Authority must be put into place. So, are these recommendations the answer to all our data privacy issues? To answer that, I have with me independent advocate Raman Chima and Nikhil Pahwa, editor at Medianama. Gentlemen, welcome to the Fineprint. Nikhil, I'd like to start with you. Are these recommendations what you had hoped for to see in India's new data protection regime?
No, definitely not. I think this is a fairly weak bill when it comes to giving users rights, because users haven't been, as far as I've read, because this is a long bill and it's a long report, users haven't been given the rights over their own data, in the sense that even when you port the data out of a particular company, you don't have the right to getting that data deleted. When there's also insufficient transparency. You cannot. You're only getting summaries of your data and not getting access to your entire data set. You only get it when you ask for porting. There isn't being done enough to address issues of mass surveillance. When it comes to data localization, there's mirroring of data that's being kept mandatorily in India, which is impossible at an internet scale. So I think it's a fairly unfortunate bill that's come out. I don't think this should pass in Parliament in its current state.
Okay, I will ask you to deliberate a little more when we discuss the data principal rights. Raman, the starting point of, or the foundation of this report was the landmark Supreme Court verdict that had upheld the right to privacy as the fundamental right. Are the committee's recommendations in line with the principles laid down by the Supreme Court?
Well, it's building a bit on the judgment, but to be honest, it's not really expanding upon what the Supreme Court said. And the Supreme Court made it very clear. The government had a duty to create a strong, effective regulatory regime for how the private sector treats our data. And the government was also restricted in how it could spy or surveil upon citizens and had to do more on tightening that up. Unfortunately, it's not done the latter at all. This law does not touch existing Indian law or practices regarding wiretapping, state surveillance, or all the sort of stuff that law enforcement or intelligence agencies do to too many Indian citizens all the time. And on the part about data protection, it's unfortunately, well, it's better than nothing, but it's not what the Justice Srikrishna Committee could have done. It could have been stronger and tighter. So it's in line, but really not. That's not much of a statement to make. Their job was to create a strong, effective law, and they've kind of just about delivered the bare minimum required.
Okay, and where do you think the principles that the Supreme Court verdict had enunciated, the recommendations don't do justice to them? Can you delve in it a little more deeper?
Absolutely. Absolutely. And the Supreme Court judgment talked a lot about consent and how consent is critical when you give your data. You need to be notified about when you're giving your data, when it's being further treated, and that consent is a critical part of this. And then consent is not just a principle of data protection law, but it comes from our fundamental right to life and liberty and to Part 3 of our Constitution. Instead, the current law seems to give many carve-outs where consent may not always be required. It's given, in fact, a very wide set of carve-outs for when government government processes data, saying that government can process for welfare schemes or other sorts of programs or authorize under law, and then only very little small tightening steps like saying, yes, that should be necessary and proportionate, and maybe the government should be doing that cautiously. So it's trying to adopt some of the language and buzzwords of the judgment, but that's just about trying to make sure that it passes bare minimum judicial scrutiny. And when it comes to surveillance, where the Supreme Court actually said that surveillance in India needs to be not just necessary and proportionate, but must also be done in the least rights intrusive way as possible, and set out many other criteria. Instead of using that as a signal to fix its own regulations or law regarding interception, for example, under the Telegraph Act and under the Telegraph Rules, or even in the Information Technology Act, this bill is completely silent. And what's particularly damning is that even as far back as 2011, under the UPA government, and even in the first year of the NDA government, the then version of the privacy bill that was being considered actually said that surveillance law needed to be updated, needed to be modified, and the current practice where only civil servants sign off on surveillance requests in India had to change. And the committee report appears to be silent on that, and the bill definitely doesn't contain that. So they seem to have completely left that for the future, and that's a wasted 9 months in my opinion.
Okay, so surveillance is one aspect where the bill, or rather the recommendations, fail us. Okay, so let us go into a little more detail on what these recommendations are. And if I were to bucket these, they would fall under, let's say, 3 categories. It comes down to what data needs to be protected, how it should be protected by those who collect it, and what happens if there is a breach. Nikhil, the committee has categorized data into personal data and sensitive personal data. The definition of personal data, they have said, should be based on identifiability, and the Data Protection Authority may issue guidance on the standards that will apply. And that definition again needs to be fluid. What does this all mean?
So look, I think what's happening is that the boundaries between personal data and sensitive personal data are quickly blurring, and the committees fail to address that aspect. I mean, from a definition of personal data perspective, it's the identifiability that they've addressed. I don't see what more they could have done here. One good thing that's happened here is that under the offenses, they have said that re-identification using anonymized data, so de-anonymization of data, or re-identification of individuals using anonymized data is an offense. So that's a good thing that's happened here.
Give me an example. I mean, what does this mean in real life? What can happen that, it can qualify as an offense?
So I think, look, there are examples of let's say, Netflix had released, location-wise data once on movie preferences in a particular area, and someone correlated that with people's IMDb's reviews, and were able to identify movie preferences of each of individual households in that sense. I think that's one of the things that had happened. So there are ways of taking anonymized data, finding other data sets that can confirm some of those, and re-identify individuals and their preferences. So that has, by the looks of it, has been disallowed.
Okay, so that seems to be a good move. Let me now come to how this data needs to be protected. The starting point, and Raman, you touched upon that a little, is consent plus a test of harm. So even after I've given my consent, if a harm is caused to me, the data fiduciary can be held liable. How will this work? And to your mind, is this an adequate safeguard?
No, I think they could have done slightly better there, because if you notice as well, there's a term about allowing data to be transferred to others for processing. At that point of time, there is no requirement for notice under the current bill they propose, which means, for example, if you're an X company and you decided to give my personal data or my personally sensitive data to another company, it's not clear whether I would be notified that that's happening, or when it's happening, or perhaps at the beginning when you first collect my data. And that's troubling, right? Because it allows someone to tell you at one point of time, but then quietly give it to all sorts of other entities. So it's a broken model they proposed, and one that unfortunately it seems like they've not learned from global best practices, including the European Union's general data protection regulation on that regard. So that's one of the concerns there. And really, the other reality in terms of how this works is that consent requires you to keep policing it, which means that it's something that the Data Protection Authority must be readily confirming to facts that you can go, not just complain about to a data fiduciary, and they use this odd term, data fiduciary. The rest of the world uses data controller, but that's the term they've chosen to use here. But that you could go to a data controller and say, I need to be told what's going on and give me, notice. The bill's still silent on how that would happen in India.
Okay, but I would think that when they are saying that if you're causing harm to me as a result of whatever that is that you're doing with my data, I will have recourse. Should that not address some of the concerns that you have raised and tie this to the limited purpose or the stated purpose test? So if they've not used that data or if they've not collected that data and not stated at the time that they've sought my consent that I'm going to sharing it with XYZ, will they still not be held liable?
No, so that's a problem, right? You have to show harm. And in reality, that might seem like a minor thing, but it's not. I would have to go as a general user, forget the fact that I'm a lawyer or I work on tech policy. Imagine a general user. They'd have to go and say, first, this entity has transferred or collected data or provided to a third party without notifying me, without taking my consent. And then I have to go and show that I've suffered harm. That is a tricky set of criteria to do. In fact, you're already stacking the deck against an everyday user. So I would rather have a simpler system where it says that if you have not notified someone and you've not taken their consent, that is not permissible. And it shouldn't be just about showing harm. Maybe if you are harmed by it, you have a right to additional recourse or additional penalties or additional criminal action or like regulatory action against the entity. But it shouldn't be that you have to show harm. That actually makes it harder for everyday citizens to be able to exercise their data protection rights.
Can I not point out that because these data collectors seek an overarching consent from consumers, if you remove this theory of harm, it would work to the detriment of the consumers, right? And Nikhil, please weigh in on here, because they have said for consent to be valid, it would have to be free, informed, specific, clear and capable of being withdrawn. And for sensitive personal data, consent will have to be explicit. All this sounds nice, but if you remove this theory of harm, I'm not sure if consumers today absolutely understand what they are consenting to. So would you not say that this test of harm is important and crucial for consumers?
Yeah, so look, the test of harm is important, but it shouldn't be contingent on just that. As Raman was saying, not taking consent is also, let's say, for giving for processing. That also needs to be included. So consent is important. That needs to be improved. I don't think this has done anything to improve the accessibility for people who may not understand what they're consenting to. I don't think this is going to improve the terms and conditions that we have to go through at this point in time. It's not simplified. It's not, even if it's specific, this is going to be full of legalese. So one is to improve consent so that there is a meeting of the minds. We know what we're agreeing to when that happens. And second is to also govern by harms, even though that is very difficult.
Okay, Nikhil, please simplify this for me. Let's say tomorrow I'm going to a hospital and I'm giving them a bunch of information about my health condition, my past history, etc., etc. Now, let's say the same hospital also runs an insurance arm. Are you saying that this hospital will be able to give this data to its insurance arm and not take my consent for it?
I'm not so sure about that. Maybe Raman can answer that.
So in case of health information, that would be sensitive personal information. Based on my limited, quick initial read of the bill, that would be something that would be restricted. But say information about where you are, your basic, personal information, let's say not your sensitive information, it would be potentially possible for the health company to share that with the insurance company. And that's the problem when we said about harm, right? If I wanted to complain and say, look, you've not notified me that you as a hospital are sharing it with your insurance arm, or that, for example, like it's been further processed, and you've not taken my specific consent for that. Currently, under this legal language, it seems that you would have to go and show, no, it's not just the fact that they've not taken consent or they've not notified me, but I've suffered harm due to it, which basically means you're stacking it higher for a general consumer or citizen to be able to really come and say, I object to this. By making a requirement for harm to be shown, it's actually harder for everyday people to be able to file a complaint or object.
Okay, so in my example, if I can use it for illustration purposes, you mean to say the fact that this hospital can share this data with its insurance arm, that transfer in itself should require my consent.
Exactly.
And
or you should be notified at the beginning, and your explicit consent, not generally. So it should be taken.
Okay,
Sorry,
and that's sure, and that's what you're saying is missing in the recommendations and the bill in the proposed form. Okay, Nikhil, there is also this concept of community data that the committee has looked at, data which, let's say, at an individual level may not be as useful, but put together with many others becomes important and crucial for data collectors. They've given the example of, let's say, Google Maps. How will consent for such data work?
I'm sorry, I haven't read that bit in the law. So I can't really comment on it.
Okay, Raman, did you spot that principle weaved into the law?
I spotted that, but again going to the depth of it. But what I'd flag is, look, even things like crowdsourced projects where you take lots and lots of inputs from different people, in reality you must obviously notify and consent and seek their consent when you're taking their personal information. There may be some information that's not personal, that may not be sensitive, which is a higher standard, but you must still make sure that you're going through a consent and notice framework. So we need to tighten that up, and I'd just be cautious about creating ideas like community data and other things like that, because the reality is there's information that is personal information, there's some information that are public records, what government and other entities hold, and the stuff that can't necessarily be identifiable to people. We should stick to that. That's my general preference of it, but again, let's see if we can tighten up that language as this bill moves forward.
And what do you then do with information that you can't identify with one person, but as a collective, it may throw up interesting business ideas for data collectors?
So that's a concern, right? So on Google Maps is a great example. Google Maps, you can actually identify who gives you data, who's providing it. If it's anonymous third parties, the point isn't about, them making an edit on your map. It's the fact that they logged in from X IP address, and you can potentially trace where they're located. Obviously, that's personal information. Obviously, that might even be sensitive information, and you must protect it. The bill, and rather a general data protection law doesn't say that you can't collect data. It says that you just need to know who you're taking it from, for what purpose, tell them what you're taking, take their consent. And instead, by creating a community data framework, you're trying to say if it's community data and we can't trace who it is, then maybe we don't need them, to take their notice. That's a bit dangerous, because nearly every tech player will start trying to say that this is community data, not personal data, and that can cause issues. Okay, got it. Nikhil, there are a bunch of rights.
Sure, please, go ahead.
I had a small topic on consent. One of the things that I noticed was the removal of consent. And there's a line in this, there's a clause in the bill that says that the liability or the impact of the removal of consent, the liability for that will lie on the data subject who's removing the consent. That's a very dangerous line to put in, and it goes back to that core idea about who owns this data. If you're saying that if I've given my data to someone, I'm removing consent and not allowing them to collect more data, I have the liability for removing that consent. That means that I don't. It's weird that they've actually included this.
Raman, do you want to weigh in what situations it can be harmful for data subjects?
Look, the only comment I'd probably broadly make on this one is that you need to notify, you need to seek consent on specific grounds, you need to seek consent in intelligible ways. That's not say like long, detailed legal document each time. You have to say, look, here is XYZ data I'm collecting, as well as give people an option that, look, you can still use my service, but I may not collect X bits of data about you. So for example, if you visited websites recently, many of whom are seeking to be compliant with the European Union General Data Protection Regulation, they actually say, here are the fields of data we collect about you. We're notifying you about this. We're also giving you the option to, opt into specific data collection or opt out of specific stuff there. You need to be that granular. And if you're starting to give carve-outs, it can be problematic. To be honest, I'm more worried about the fact that they're giving very broad carve-outs for consent when it comes to data you give to government, and the arguments of that either if the data is being collected under a law another law, or if that data is being collected for welfare purposes. That can be particularly dangerous because in reality, government agencies in India are one of the largest data collectors, right? Whether it's the union government, its agencies, or state governments or public sector corporations or banks, they're a huge data set and often have very sensitive information. So we need to be very cautious about consent, particularly when it comes to giving government our data.
Sure, Nikhil, I'm not sure if you could spot this, the problem that I think consumers face on a day-to-day basis, that if I'm not consenting to, let's say, the terms and conditions of a certain app or a website, or to, let's say, cookies on a certain website, I am logged out of there, right? I can't access those services, I can't read the content on that website. Is this selective consent a provision that the committee has recommended, that I am okay sharing XYZ, but not ABC about me? Can I do that as a consumer once this data protection regime comes into play?
So I'm not very sure. I think I remember reading, because this is it's a fairly complicated law and very detailed. You will not be denied a service if you refuse to give your data or something on those lines. I'll have to check that up, to be honest.
Okay, Raman, let me come to the final aspect that I want to talk about today, which is the redressal mechanism. What happens if there is a data breach? And they have suggested setting up a data protection authority. I spoke with Justice Srikrishna a little while ago, and he said that each sector should have a separate DPA with a common appellate authority. Do you think that's a successful model, Raman?
You're probably seeing me nod my head already, so I'm saying no. You shouldn't have a sectoral data protection authority. And I'm in fact troubled if Justice Srikrishna said that, because his bill, actually, the bill his committee works on seems to suggest one data protection authority. Maybe sectoral codes of practice, even those are bad ideas. For example, if you look at the US's problem is that it actually does not have one clear federal privacy or data protection regulator. The closest is the Federal Trade Commission, and even it has limited powers, and they're trying to fix that. In Europe, instead, what you have is you have Europe, and as well as Australia and New Zealand, as well as Hong Kong and other countries in the Asian region, you have one federal privacy regulator or a state privacy regulator, which can sometimes come up with specific sectoral additional regulations, but there's a baseline standard. And that's where we need to be at. And remember, a DPA or a privacy commissioner is not just about data breach. It's about enforcement and regulation. It's about checking the practices of tech players, of general companies, of everyone, and telling them proactively what they should be doing, not doing, and then enforcing this when it's not working. Data breach means that if data is leaked, what are my rights? And the problem with this law as it stands today, it requires a data breach to be notified to the Data Protection Authority, but it does not require you, the user or citizen, to be immediately notified. So instead, what might happen is companies or platforms may start sending it only to the Data Protection Authority, and you have to trust and hope that they actually come and tell you. There's no legal requirement to tell the person whose data is actually being affected that there's been a breach. And that is a huge lacuna which needs to be fixed.
Okay, yeah, that's a big one. I will put my final question to both of you. Again, Justice Srikrishna refrained from commenting on what this would mean for a sub judice case, that is Aadhaar, but he did mention that processing of data will include storage. So while the law says that it will be prospective, he didn't say it so, but it seemed like that data that's already in the systems, whether public or private, will be governed by this new framework. Nikhil, what do you see as the impact of this data protection law on Aadhaar Act and some of those provisions that the committee itself has said would need to be amended?
I don't see any impact on Aadhaar. I mean, we'd heard that there would be more significant amendments to the Aadhaar Act, but I think there have been changes made to this to the draft. We've seen a couple of drafts leak. This final one doesn't seem to impact the Aadhaar Act at all. So now it's frankly just up to the Supreme Court.
Raman, would you agree with that view, that nothing that the committee has suggested is going to impact Aadhaar in any fashion? And probably, to be fair, the committee had set out to say that, look, it's a sub judice case and we will not do anything that, overlaps or could potentially overlap with what the outcome could be at the Supreme Court.
See, remember, ultimately sub judice means that you can't comment on what the Supreme Court might say or do. You can decide at the policy and legislative level, we are going to fix this. For example, more proactively, if the government of India today decides to say we will not do Aadhaar for the future, notwithstanding what we said in court, they are completely free to do that. The reality was that Justice Srikrishna and this committee was given a mandate to ensure that data is protected strongly across the public and private sectors. That means that data collected both by private entities in the past as well as by government, as well as by the Aadhaar project, obviously needs to be under scrutiny, because otherwise what you are doing is you're telling people this law may come in 1 or 2 years. In the meantime, hoover up as much data as you can. This law will not apply retrospectively. There is no window or grace period or warning period of regulatory oversight. That's troubling. And what's even more worrying is that they have proposed amendments to the Aadhaar Act, but they've given that as a completely optional set of recommendations in their 230-page report, not in the 67-page bill they proposed. Instead, that bill proposes amendments to the landmark Right to Information Act. It says that a section there should be modified and amended. It puts that there in the text that they propose MPs vote on. They do not include Aadhaar Act amendments in it. So it literally means that RTI amendments, mandatory according to their bill. Aadhaar Act amendments are optional. And that's a disappointment, and I would argue that that's really a failure, not just in imagination, but in courage. But one hopes that the minister reconsiders that. The minister doesn't reconsider that, and the Prime Minister and the Cabinet don't. Ultimately, MPs are free to think and vote differently, and one hopes they do.
All right. Well, gentlemen, thank you for sharing your initial thoughts on a quick read of this over 200-page report, and some of the lacunas that you both have pointed out in the report hopefully will be addressed in the consultation process. Thank you for joining us on the Fine Print today, and thank you so much for watching.